Good day. This is the online lecture for LML4805 Learning Unit 7, specifically focusing on misrepresentation. Now, I'm going to just refer you very much back to the addendum A, where again you can find the bird's eye view of the learning units and look at the diagram and see how everything would flow. Also, I will insist again that you need to study and read the cases as well as all the articles that are prescribed to you. Read your study guides, study the parts in Reneke and all that are referenced. You will need to do all of that to truly understand this. This is merely a guide for you to go through so that you know what misrepresentation is. Let me be your guide. Thank you. Now, again, and I'm saying again, it's just that in the Learning Unit 6, I referenced the background, and it's very important that we are talking about insurance contract as a contract, but also as a specific contract. So all of the things that you need for this very specific contract will be required, and a lot of the things that I'm talking about now are things that will negate that, so whether those essentialia are present. Now, good faith is a requirement. Of course, we have a good faith as a requirement for all contracts. What does that mean specifically for insurance? It's very interesting. We, in English law, they have a concept of utmost good faith. And for some time, we thought that we also had exactly the same. However, in the case of mutual and federal, they looked at good faith and the kind of requirement we had, and it was it was clarified for us, firstly, that we do not have the English requirement of good faith, and secondly, that the good faith required, there are no degrees. It is just that it is good faith, and it's as required for all contracts. So there's no, it's not a special distinguishing feature of insurance contracts. And just like all other contracts, misrepresentation negates good faith, and that is, it has an impact on that consensus that you need. So you need a consensus on the vital, essential terms of a contract, and if that consensus is absent, people can sometimes make a mistake. But you can also have innocent or an actual decision to make an incorrect decision. So it could be that it was done innocently or not. You reach consensus, but it's based on incorrect information. That contract there is not void, but it is voidable. And of course, quite important to realize already that that incorrect statement can be from the insurer or the insured, not just from one of the parties. But of course, the cases that we are referring to tends to focus very much on the actions of the insured. So one of the ways consensus can be obtained improperly is through misrepresentation. And that, of course, the impact of consensus, for example, on the rate of premium or other material facts, it could mean that the premium is very low because you did not say that the car will be parked on the road as opposed to inside a locked garage. So those are very important things that you need to have consensus on. What is that impact then of misrepresentation? That the insurer, we are really looking at from the sort of example of the insured or the proposer, really, because that person is only insured after the contract is concluded. But the proposer, the person who wants to get insurance, responds to a series of questions generally or otherwise, and their pronouncements, their statements, induces the insurer into entering into an insurance contract. And that, of course, would make the insurance contract voidable, but at the instance of the insurer, who, in some instances, could also claim damages. And that means that when we are looking at misrepresentation, we are really looking at a delict having occurred. You're not talking about a breach of contract. We'll get to that under warranties. And sometimes the same statement can be both, but I would rather we deal with it there. So you need to have all of the usual requirements for a delict before an insurer can, of course, void the contract and or claim damages. Excuse me, my nose is itchy. Misrepresentations can take the form of positive or negative misrepresentation. So a positive misrepresentation is where you are asked a question, do you have a family history of heart attacks? And your parents have had it, or your grandparents have had it, your uncles have had it, and you say, no, perfectly happy and healthy. No one has ever died of a heart attack. That is a positive misrepresentation. A negative misrepresentation is where you fail to disclose a material fact. So though they haven't asked specifically about something, you know that this is an important thing. You're trying to get a life insurance, and let's say you have information, for example, that you've been diagnosed with a type of cancer. It wasn't specifically asked, and I'm just going to keep it to myself. That would be a negative misrepresentation. By omission, that is, by not giving the information. Again, there are linkages to warranties. So, for example, where you have a vehicle and you say, well, yes, I'm going to be taking very good care of this car. I love it. I'll be putting it in a locked garage. And that positive misrepresentation would then be something that the insurer can rely on as a warranty to say, well, that is how you will act. You've agreed to it, that you will always lock it up. Except you are not going to do that. You don't want to do it. It's too much trouble. You leave it outside on the public road. Then that same thing could be a breach of contract through breach of warranty, but also a delictual act through positive misrepresentation. Just keep that in mind. We will be talking much more deeply about warranties. Now, to resolve some of these issues in our law, we do ask that the insured carry a duty to disclose. So the insured, has a very specific duty to provide information to the insurer on material facts. So yes, they have a duty to disclose, but not everything. So that is very important. It is important for the insured to provide that information because some of that information is only information that the insured knows. And of course, that will impact and influence the mind of the insurer. So the proposer has a duty to disclose, but it only pertains to material facts, information that the insurer does not already know. If there are certain things that you might expect the insurer to already know, you don't have to disclose that. And of course, if the insurer has waived, they say we want to give life insurance to everybody and not take into account any information about your health or that sort of thing, then they have waived the right to get that information. The duty to disclose is all material facts up to the time of the conclusion of the contract. So let's say somebody is trying to get health insurance. They get the insurance, they agree, the contract's signed, and a year down the line, this person finds out that they've been diagnosed with cancer. They had the disease, but they didn't know about it. The diagnosis only happened after the fact. The duty to disclose was only up to the conclusion of the contract. it is very important that this specific duty is subject to severe criticism for the mere existence of it as well as the scope. So please, have a good read. I'm again giving you a basic guideline. It's up to you to really go and interact with the materials given to you. When it comes to misrepresentation, and here we are looking at all the different parts of delictual elements that need to be present for misrepresentation. So you will need conduct, wrongfulness, fault is not necessarily the most important requirement, but and it depends on the situation. Generally, is assumed to exist, and we don't, even if it's an innocent misrepresentation, fault is not an important requirement. Causation and of course harm is important when you want to claim for damages, when the insurer wants to claim for damages. It is important to note that an incorrect statement is wrongful if it relates to material facts. So we are already saying it is already wrongful. And that takes us to the next step. How do you know whether it is a material fact and whether it's relevant to the risk? And this has, at the appellate level, really caused a lot of discourse, and it's fascinating to see, and I would suggest you read those cases quite closely, and I will be referring to them in a couple of slides. So what we needed to have is a test to find out what is material. Now, there are cases that are prescribed to you as well as articles, and in the textbook itself there's a good discussion of this, so please look at that. And what is also very good to keep in mind is that some of the cases were dealing with positive and some of them were dealing with negative misrepresentation. And the decisions therefore were quite different based on that as well. In the outswearing case, a case of negative misrepresentation, the test applied was that of a reasonable person, so not the reasonable insured, not the reasonable insurer. This was an appellate case. In the appellate case of Kilingile, the case was that of a positive misrepresentation, and here they said you have to look at a subjective particular insurer, so it was not an objective test. And that the reasonable person test should only apply to the negative misrepresentation. Now, the Clifford decision criticized the subjective test that was decided in Kilingile, and it's very important to sort of look at these cases chronologically and see how they interact with each other and the reasoning behind those decisions. I don't have the time to do that now, but please read your textbook. There's an excellent discussion there. Read the cases themselves. It's a fascinating part of deciding what is material. The differing cases that created, of course, an issue around, interpretation of laws, and it created confusion. They muddied the waters, really. And then legislative intervention was done in 2003, and they said that the test for materiality would be the reasonable person test, for both positive and negative misrepresentation. Fascinating. The other elements of a delict would be that there should be some form of causation or inducement. So yes, it is a material fact, but also that the insurer then concluded. So there's a link between the two. So there's a link between the material fact and the conclusion of the contract, and that inducement has to be present. Another requirement for delictual liability is fault. Of course, that is necessary when the insurer wishes to claim for damages. So what are the consequences of and remedies? Firstly, of course, the usual remedies. So you will have that makes the contract voidable, and the insurers have taken a second step by providing in the contracts that if there is misrepresentation, the contracts could be avoided. And also, they do, in a lot of instances, put in a forfeiture of rights as well. Any rights that are due to the insured are forfeited. So they will put those in. Of course, these remedies are available to the insured as well, because when an insurer has made a misrepresentation, so of course, just remember that. I know we've sort of focused very much on the example where the misrepresentation is by the insured, but it's also vice versa. And I think that concludes our discussion around materiality. Again, please read all of the cases, read the articles, study the textbook. This is a guide to just help you through the material. Thank you.